Dear colleagues, dear students, today I want to speak about the rule of law as a universal and multi-level principle and make some consideration on this subject. In my lecture, I would like to address the question whether the rule of law as an important constitutional principle is valid not only at the level of national states, but also at the extra-national level of the supranational and international legal order. To this end, it is to be clear about the levels of constitutional law that are relevant in our context and how they are interlinked. This highly complex subject can only be outlined here in important basic lines. In this regard, I must immediately explain that the term constitutional law is traditionally used for the area of national law, but that this term can also be used in a functional view for the non-national area. Thus, the law of the European Union, at least the fundamentals, is also referred to as constitutional law, at least so by the Court of Justice of the European Union and by a large number of views in the literature. The European Convention of Human Rights can also be seen as functional constitutional law, and it is even possible, in my view, to assign this character to human rights guarantees at the global international level. Furthermore, we must deal with the concept of the rule of law. We have to clarify what the rule of law means and whether the meaning found in national law is also essential for the transnational level, that is, in the context of the European Union and, to a certain extent, in the context of universal international law. Let's start with our reflections. First of all, it must be stated that constitutional principles such as the rule of law can no longer be considered from a national perspective alone. Fundamental rights and other principles, which include the rule of law, must be encompassed in the constitutional network of the various legal orders. The perspective of national law alone is no longer sufficient in today's constitutionalism. The reason for this is that the legal systems are interlinked. This is a consequence of what we often call open statehood. The tasks of the state today can largely only be solved transnationally. The state must open itself up to cooperation with other states and in particular with international organizations. In regional areas, so-called supranational communities are even emerging, such as the European Union in particular. These are associations of states with the highest functional power. Indeed, they partly replace the organizational form of the state, at least functionally. Germany, to take this example, is, like all other member states of the European Union, closely connected with the supranational community. The law of the Union claims precedence, primacy over national law. It has a direct effect on the national legal order. It influences and even replaces the national legal order to a considerable extent. This also applies to constitutional law. Certainly, the constitutional law of the European Union member states is autonomous, but it is linked to European Union law. Let us take the Charter of Fundamental Rights of the European Union as an example. if the member state implements European Union law, it is not the national protection of fundamental rights that is applicable, but the European Union protection of fundamental rights. That is the European Union Charter of Fundamental Rights. Or a regulation of the European Union is directly effective in the member states, even prevails over national constitutional law. Here, however, some constitutional courts, such as the German one, have established the so-called national constitutional identity as a limit of the influence of supranational law. And on the other side, the German Federal Constitutional Court has repeatedly stated that German constitutional law must be interpreted in the light of the European Union law, in the light of the European Union Charter of Fundamental Rights. So we see a very intensive linkage of the two legal systems, the two legal levels. The relationship between national constitutional law and regional international law, that is the European Convention on Human Rights, is also very important. This convention binds the 47 member states of the Council of Europe, including all European Union member states such as Germany. Thus, binding relationship under international law has ultimately also led to the fundamental and human rights contained in the Convention on Human Rights being understood as an aid to interpretation in the interpretation of German fundamental rights. German constitutional law is thus understood in the light of the convention law interpreted by the Strasbourg Court of Human Rights. This is also a very strong linkage from the state level to the extra-state international law level. It should also be mentioned that some states, such as Spain, explicitly prescribe in Article 10, paragraph 2 of its constitution, the interpretation of national fundamental rights in the light of the international fundamental rights instruments. Furthermore, the universal human rights covenants, that is the global level of international law, also have an influence on national constitutional law. One need only think of Article 1, paragraph 2 of the German Constitution, according to which human rights as such, whether guaranteed nationally or internationally, are the yardstick for justice and peace par excellence. This provision obliges Germany to align its value system with that of the international community. This provision also documents that the values associated with human beings, the anthropocentric values, have universal validity. We thus find that the basic principle and value definitions of the Constitution, the fundamental rights, and also the basic principle as the principle of the rule of law, there is a functional unity that far transcends the national sphere. This also promotes a tendency to reach a converging understanding of values within the framework of all actors and bearers of genuine constitutionalism. This convergence process is not based on a unilateral influence of extra-state law on state law, but on a process of mutual influence and filtration of an optimal overall solution. A clear example is provided by the European Union Charter of Fundamental Rights, according to which its fundamental rights are to be interpreted, on the one hand, in the light of the European Convention of Human Rights, and on the other hand, to a large extent, of the common national constitutional traditions. The principle of the rule of law is closely linked to fundamental rights, but it is an objective constitutional principle that has a common core at all three levels: the orientation of public power exclusively to law, to the legislation, and beyond that, to the constitution. The primacy of the Constitution is a hallmark of modern constitutionalism and is an essential component of the principle of the rule of law. Not political power, not the rule of the strongest, not arbitrariness. No, only the rule of law can be the supreme and sole maxim of genuine constitutionalism. The rule of law today is at all levels also value-bound rule of law. If the supreme goal of law is, in general terms, as Gustav Radbruch already expressed it, the protection and promotion of man, of human being, then the orientation to law can only be the orientation to man-related, anthropocentric values, human dignity, the principle of freedom and equality. Thus, the rule of law reflects the basic values order of the real constitution. We can see this both in the state and supranational law of the European Union and also in the European Convention on Human Rights. Also in the global international area, which is substantially coined by the state-related international law. Nevertheless, also with the human right covenants, constitutional structures are formed. The value orientation is the same. The human being stands in the center. The concept of human dignity, as far as the term is concerned, has been imported into national constitutional law via the international documents. And think of the Universal Declaration of Human Rights of 1948 and of the United Nations Charter of 1945. So we see a broad convergence in the basic idea of the rule of law at all levels. At this point, it should also be briefly mentioned that the continental European and Anglo-American concepts of the rule of law differ in content. From an English perspective in particular, the rule of law as a concept has so far been grasped only in a reduced form. Since in this legal system, the Act of Parliament is the supreme source of law, there is no formal constitution that ranks higher than the legislation. Nevertheless, the elements comprising the rule of law in English law certainly cover those of the rule of law concept in the continental European sense. What are the specific manifestations of the rule of law? The rule of law requires that the law is binding on state institutions. The principle of legality binds the executive and the judiciary to the legislation. The principle of primacy of the constitution binds the legislator and also the executive and judiciary to the constitution. Effective legal protection is also part of the enforcement of this obligation. This is along the rule of law. More recently, the constitutional courts also review compliance with the constitution. The rule of law in the sense of constitutional state also includes this requirement. There are, however, various possibilities for this. Constitutional review by constitutional courts of their own, Hans Kelsen's model, or the American model of legislative review by ordinary courts. Compare the famous decision of the United States Supreme Court in 1803 in the Marbury versus Madison case. Rule of law further includes the function of law. Clarity and definiteness of the legal norm of the law is important for the possibility to obey the law. This element is particularly significant in criminal law, where precise knowledge of the law is important and where analogies to written law are prohibited. Legal certainty is an important element of the rule of law, requires that a well-acquired legal position, that is the attainment of a legal position in accordance with the existing law, is secured and has force against changes in the law. This area of the rule of law also includes the prohibition of retroactivity. Legislation may not intervene retroactively in completed legal situations. This applies in particular to criminal law, but also to other legislation. There are very narrow exceptions to this rule, law, a rule, however, not in criminal law. The prohibition of eliminating legal positions once they have been acquired is often referred to as the protection of legitimate expectations. The protection of confidence is of great importance in the legal system. The connection between rule of law and the values order has already been mentioned. This is particularly important in the case of attacks on the freedom of individuals on their fundamental rights. A restriction of fundamental rights may only happen if an intervention is necessary and it must be proportionate. In other words, no excessive intervention. The function of the principle of rule of law also includes the safeguarding of freedom. This is already expressed by the connection of the principle of law with the anthropocentric values. The safeguarding of freedom is realized not only through judicial protection, but also and especially through the paramount requirement for the separation of powers. No freedom without law and no freedom without the rule of law. This applies in particular to the various forms of separation of powers, the inter and intra-institutional separation of powers. As a result, we can state that the principle of the rule of law is a universal principle. It is guaranteed at all three levels, the national, the supranational, and the international level. The individual elements are largely the same, even if their form may differ. Ultimately, the rule of law serves the human being. It serves freedom and thus human dignity. Thank you for your attention.